And I would then compile a memorandum, in brackets, an application addressed to the investigating director, motivating for the authorization of an investigation. Maybe just to add, Commissioners, the application or this memorandum, in the said application, I'll then set out the summary of facts as we would have detected them from, say, from the Zondo Commission report. A particular case, I just want to give an example, maybe let's say that deals with Sunday trading. I'll then encourage all my group members to read the particular chapter of the commission, and let's say we identify that particular case. We then summarize the evidence, and which is then going to form part of this application that I'm directing to the ID. And in the said application, I'll also then request the ID, if she finds that to be in order, to authorize the matter, either in terms of section 28(1)(a) or 28(13). And I also, in the application, ask her to authorize the designation of the officials that I would have listed in the application: financial investigators, data analysts, and so on. And the ID would then consider the application, and if it's approved, we then get a feedback via the project manager. Then we start working on the matter.
Purely out of interest, how would you identify cases that you would end up dealing with? Do you just rake through the record and say, oh, there's another one? You continue, there's another one, and then you deal with those. How exactly would you?
Yeah. Chair, like I indicated in the earlier paragraphs, I was overseeing a group that was dealing with high-level corruption in the public and private sector. So
I'm talking about commission matters, not, that's my focus, not your section 27 referrals.
Yeah. We read through the report. The commission, Judge Zondo made certain recommendations. Okay. For example, when the commission would have dealt with the matter, they then make a recommendation whether law enforcement should look into that. There's recommendations which are direct to say prosecution should be considered. And we follow those type of cases where recommendations
that would direct you to, and then you go to the relevant parts of the report.
That is correct.
Okay, all right, all right.
And then, Advocate Sirinya, in terms of the designation, when you give it as part of the application, do you indicate the individuals who will be forming part, or who exactly chooses the composition of that team?
That is true, Commissioners, I do. In the application, I include a list of names of people.
And so it would be the DDs in their applications who would designate who would form part of the team?
Indeed. Always in each of these cases, there must be a deputy director of public prosecutions who's the project owner, who's heading the group. And I must then have a balance of officials, a lead criminal investigator, a lead financial investigator, and maybe a junior criminal investigator and a junior financial investigator, prosecutors. Depending on the complexity of the case, I might have maybe two senior state advocates and a junior, and try and balance the team like that, including a data analyst and so on. But then I'm requesting the ID to then, and if she finds that to be in order, to approve that. I'm not making a decision at a time, it's just an application. The ID will then go through that. Sometimes she will then suggest, include chief investigator, or maybe include two more prosecutors and so on. Then we change the documents, provide them to her again, then she signs it off.
Whether a section 27 referral or a commission matter, would a matter ever commence within IDEC without a Deputy Director of Public Prosecutions being a part of the team? Ordinarily.
That shouldn't happen. That shouldn't happen.
Did it?
Chair.
Did it? Ordinarily, did it ever happen?
There must
Let's not talk about the matters that we are dealing with now. Ordinarily, would that ever happen?
It will never happen. There must always be a deputy director, because as we go on with the investigation, there are documents that must be signed by the deputy. There's communication that we must make with outside stakeholders that must go under the signature of the deputy director.
So from inception,
From inception,
deputy is involved.
there must be a deputy
All right,
who's the project owner of the project.
In the application that you submit,
Yes.
and you say that because in the nature of an application which is approved by the ID, you say she could make recommendations or suggestions that include others. In your experience, has she gone so far as to specify who by name, not just include another 2 investigators or a prosecutor? Have you had that kind of experience?
I've never had such an experience, commissioners, but she would suggest, maybe looking at the balance of the team, that you still need another prosecutor, either a junior or a senior, without specifying a name, without recommending, include so-and-so. She would just advise, beef up your team, you still need another data analyst or this or that, but without specifying a name.
Okay. And again, your experience, have you had experience where the ID picks the team for you? Have you had that kind of experience where she specifies these people that she has already spoken to, and you're married to them, so to speak?
I've never had such an experience, commissioners. It has never happened.
Thank you.
Yes.
I'm sure when you say it has never happened, you're not talking about the cases that we are going to be dealing with now.
I mean, in general, it has never.
Because on the face of it, it appears that what Commissioner Baloyi is asking is exactly what happened. That which you say has never happened appears to have happened in this instance.
Indeed, Chair, but the question, as I understood it, was, in my experience personally, to me, has the ID ever recommended to me that a particular person or team be, and that has never happened to me.
Okay, all right.
And from paragraph 18, depending on the strength and detail of the available material, the memorandum would motivate either for an investigation under section 28(1)A of the Act, or for a preparatory investigation in terms of 28(13). Such memoranda were ordinarily prepared and issued in my name as the DDPP responsible for the group. I deal with the oversight structure in brief in paragraph 19.
Advocate Sirinya, before you deal with the oversight structure, just to understand in the drafting process of these applications, whether you are motivating for 28(1) or 28(13), who all is involved in that? Is it you, or is the entire team involved in the process of drafting?
It is the whole team. So, not necessarily that, but sometimes I'll sit with, say, a lead criminal investigator or a senior state advocate, but there are instances where I'll sit with the whole team, and because I would have said to them, read here, read those parts, let's deliberate. I'm intending to do the following, and therefore, as a team sitting, I'll also then get advice from other members of the team to say, Didi, maybe here, let's go for a 28(13), or let's go for a 28(1)A.
And in your experience, has there ever been a situation where the ID indicates to you that please draft an application in terms of either 28(1) or 13?
No. it has never happened to me in that sense, but there are instances where, let's say, my memo would ask her to authorize it, the matter in terms of 28(1)(a), but after going through what we would have presented before her, I know of one matter where she would have said, no, not at 21(8). She then make notes on the memo. She sort of recommends or does not recommend. When she recommends, she make notes, or if she doesn't recommend, she also make notes saying why. Sometimes she can call me in and say, the evidence is insufficient, maybe at this stage. Maybe I propose you go for a 28(13), but she always make notes on top of that memo so that you understand when I go back to my team, I can also brief them to say, this is the outcome of the application.
In those instances, it would be on the back of you having made an application, not necessarily that she would approach you to say, make an application on her own, as it were.
Indeed, Commissioners, I would have made an application, and she then makes her recommendation. She has never approached me to say, I want you to do an application for this specific matter or for that specific matter. Neither has she ever said to me, include so-and-so in the application and don't include so-and-so in the application.
Right, thank
or
you.
in the matter, at least.
Thank you. You can proceed with the oversight structure.
Right. On paragraph 19.1, the investigating director, Advocate Andrea Johnson, heads the unit. The head of investigations and operations, the position is held by Mr. Matthew Sisoko. He sits at the same level as deputy directors and reports directly to the investigating director. Maybe you can just explain there. We have the ID as the head, and we have the 4 deputies directly underneath the ID, all of us reporting directly to the ID, and Mr. Sisoko is sort of on the same level with us, reporting to the ID, but we also on dotted lines report to him. He calls meetings, and we brief him on the cases because he has to directly report to the ID.
You say in your statement the dotted line reporting is in respect of, I think you said, operational matters. Would that be administrative matters, or what are operational matters? Because you say regarding your work, you report directly to the ID. I just want to have an idea of operational matters.
Yes. Chair, we report to Mr. Sisoko on, we brief him as the investigation, as we're busy with the investigation, we even make reports, quarterly reports, and there's a structure which he's heading, where on a monthly basis we meet and we then present these cases to him with a view that he will then brief the ID on how far the cases are, where we need resources, we'll inform him, where we're having challenges, we inform him.
Oh, let me tell you where my confusion is. If you report to him about the progress of the matters, I would have thought that that relates to your work, about which you say you report directly to the ID. Do you see my confusion?
I get that, Chair.
And,
maybe we...
And yet you say there is a distinction in that you report to him on operational matters. That's why I was saying these operational matters, are they perhaps administrative matters, but on what you've just said now, it seems you report to him in relation to your work as well.
True. Like we're duplicating the reporting. What we report to him, to some extent, we also, when we're having management meetings or meetings with the ID where we'll be deliberating on a specific matter, we also raise the same issues with her.
It seems to me there are no bright lines as to the difference in terms of what you report to him and what you do not report to him. There are no.
I'll agree with that, Chair. That's why I'm saying we sort of find ourselves reporting the same issues again to the ID when we meet with them.
Not that it matters for present purpose or in the bigger scheme of things, I don't think. Yeah. All right.
Thank you, Chair.
Please.
Yes.
Can I just, on this same question, I also wanted to understand the difference between the kind of reporting that you do, and more specifically, the purpose that you give reports to the ID as the matter is rolling, and the reports that you give to Mr. Sissoko, what the purpose is. And behind my question, I've sort of tried to give myself an answer, that if you want decisions about a course of action that you are thinking of following, for example, we are now ready to get people arrested and presented to court. It seems to me that would be the kind of decision or report that would go to the ID. And then I'm not sure what Mr. Sissoko, the report to Mr. Sissoko would be, its purpose, what does it serve?
Indeed, Commissioners, what we report to the ID when we're ready with the takedown, those are issues that we'll discuss with the ID. We have a briefing where we take her through the evidence that we have, and decisions will then be made at that level. If she's of the opinion that you're still lacking on this or that, she has a right to advise. With Mr. Sissoko is on a monthly basis. There's this structure where we report, and if we're having problems of resources and so on, we report to him. We ask for those to be provided, and he can then help with those. If it has to be issues that he takes up with Human Resource Department, he does that on our behalf. But I want to believe that the purpose of that is for him to also then, when he reports to the ID, to say, this team in relation to this matter, this is where they are, and these are the challenges that they are having, and so on and so on.
And is it a requirement, I want to say prescribed, but that's not quite the word. I think prescribed is too strong. But is it a requirement that on a monthly basis there must be reports? All the teams must report to Mr. Sissoko on a monthly basis?
That happens. It is a requirement. That happens. Project managers are in charge of. They are responsible for doing those reports. Our meetings are held, or at least were held monthly. Yes, with Mr. Sissoko, and then we'll then report on these cases.
In those reports, and maybe let me use an example. Do you report to Mr. Sissoko in a way that he is able and he's allowed to say to you, I don't understand why you are deciding to prosecute this person, why you're deciding to arrest this person from what I have read? Is it that kind of reporting and that kind of engagement with him?
No, it is not, Commissioner. He does not question issues up to that level where he can say why these charges, why not those charges, or why. No, it's more to report to him about the progress and where we're having challenges. Where it's not about him advising on. I know Mr. Sissoko used to be a prosecutor many years ago, but the function here for him is not to advise on legal issues or anything. He's more of a CEO in charge of our daily operations. Yes.
Thank you.
Sorry, Advocate Sirunya, I was just trying to be of assistance. Maybe if we look at the operations manual, so that will be in file 10.
I have file 10.
Just to maybe I may be wrong. What is the OMC? Is this the committee that does
Yeah,
the monthly?
It's this committee that is headed by Mr. Sissoko.
Okay.
Yeah.
Commissioner, so you'll see the definition of OMC is on page 12, but the provision I wanted to draw your attention to is on page 25.
Which heading?
My apologies, on page 24, which deals with the roles in IDAC. It's 3.3. It starts at 3.3.
Head of Investigations and Operations.
Yes, you'll see there, it's, one of the duties is to convene the Operations Management Committee, and you'll also see under the topic Deputy Director Public Prosecutions, on page 25, this third from the bottom, or second from the top, provide progress report to OMC and ID. Is
Yeah,
this
what paragraph?
It's paragraph point 2 on page 25, the one that says provide progress
Yeah,
report
okay.
to OMC and ID. Is that what you're talking about?
Exactly, it is indeed so, Commissioners.
So this reporting structure is prescribed by this operations manual?
Indeed. I see the definition of OMC is Operations Management Committee
Yes.
on page 12.
Okay, thank you. We can then go back.
Yes.
I mean, for completeness, just to be clear, is this operations manual that we're looking at in effect at IDAC, as far as you know?
Indeed, Commissioners, it is. I think it was signed in 2024, just trying to get the date, by Mr. Sissoko and the ID.
That's at page 10. And this is what guides your day-to-day operations?
This is what guides our day-to-day operations. Every new employee in the IDEC is given this manual to go through what I do in my group. As I welcome the new members, I'll then arrange a meeting. Let's say we have 3, 4, say maybe 2 prosecutors, 2 investigators. We'll have a meeting. I call all the members, and as part of what we're going to deal with in that meeting is to go through the manual, you know, just for the new officials to sort of as an induction to the new officials.
Right, thank you. We can then return to your statement.
Yes.
We are
I
at paragraph
was
19.2.
At 19.2, as I'm dealing with the structure, beneath the DDPPs are the senior state advocates, and then the junior state advocates. And on the investigative side, we then, IDEC drew both on investigators, seconded from the Directorate for Priority Crime Investigation, and on contracted civilians who were hired as financial investigators. They come with experience from different institutions like banks and SARS and so on. And we have criminal investigators, including a chief investigator. Chief investigators, we currently have 2. It's Chief Investigator Perumal and Chief Investigator Boy, Nico Boy. So all the investigators are reporting directly to the 2 chief investigators. On a monthly basis.
So does that mean, because there are 4 groups or teams, does it mean that 2 chief investigators are spread across all 4 teams?
Indeed so, Chair. They're spread within all 4 groups. On a monthly basis, the deputies, chief investigators, and project managers report on each matter through a structure chaired by the head of investigation operations, Mr. Sissoko, as I earlier indicated. The investigating director in turn reports to the National Director of Prosecutions, and also to Parliament as and when she's called.
Advocate Serunye, just on how you allocate, so you indicated that the prosecutors are split into the 4 groups. Does it happen that a prosecutor in Group A, working on the security cluster, for example, can then do matters with Group C, who works on, I don't know, recommendations from the Zondo Commission?
We do have that cross-pollination. Before the time of Advocate Johnson, when it was Advocate Kronje, she wanted the groups, when you're designated to a group, you belong to that group throughout. But when Advocate Johnson came, she changed, and she was of the view that people should get experience in dealing with all the cases, type of cases, and therefore no one investigator or prosecutor is permanently based in a group. Where there's a shortage in another group, a person can be designated by that group that requires those services.
And in practical terms, how does that work? Is it only in the instance of shortage, or is there sort of a regularized rotation system?
No, it's not a regularized rotation. It's mainly when the shortages and sometimes when a new matter altogether is being designated, the deputy can choose prosecutors from other groups, especially those I wouldn't have worked with before, just to also give them a chance to deal with the type of cases that I'm dealing with in my group.
And
But there's always this core group, that I have, that I would have started with for the last maybe 3-4 years.
And then would you, in an instance where you're working with a prosecutor from another group, would you then notify the DD there that you would be making use of one of their prosecutors?
That is true, Commissioners. Before I include another member from another group, in fact, I have to discuss with their deputy first and to inform them, and we then agree as deputies that, no, you can use the person. He's not having a lot of cases with me currently. Sometimes, as we're discussing in this structure, this OMC structure of Mr. Soko, those are some of the issues that we're discussing, to say there's this other group that needs a data analyst. Is that data analyst available to be designated in that group, or this group requires 1 or 2 more prosecutors, and that is done at that level. But the discussion is held between the deputies. I cannot just take a prosecutor from another group or an investigator without informing the person that they report to. Because in the beginning of the year, our financial year runs from 1 April to 31st of March. What we do is I sign on behalf of the NPA stroke IDEC in contracts with the individual members, say the investigators, prosecutors who are in my group. Therefore, for that specific year, I have to assess their performance. On a quarterly basis, we do performance assessments and so on. So therefore, when we're having a person reporting in this group and in that group, we know that for that specific year, the person has signed a contract with, say, Advocate Friedman, and I'm also having some work that I'm doing with them for Advocate Friedman to know when she's doing assessment, performance assessment with the individual. I have to give her reports on how the person is performing in my group, what work they would have done, and so on. So there is that engagement between deputies.
How does it work when, with new matters that come in? So it's not arising from a report of a commission. We've come to understand that there's an intake process where matters they come in and then they are evaluated whether they fall into your mandate or not. So when such matters come, how do they land with you eventually as a DDPP, responsible for a team?
Yeah. Commissioners, I must say the manual talks to that process. I have, however, in my group, I've never dealt with it, Section 27, a matter which would have came via 27, but that process is it's dealt with, or at least explained in the manual. One would have expected that once the IDEC was set up, we're going to have a lot of cases being referred, or members of the public reporting cases to the IDEC. And therefore, the manual talks of a secretariat which will receive these cases coming via email or post and so on. And then there's an intake criteria which has to see it to then determine whether these cases belong in terms of jurisdiction in the IDEC and so on, which will compose of Mr. Soko will always sit in the intake criteria according to the manual. There'll then be a deputy and a chief investigator, I think, and it also recommends either senior state advocate or a chief investigator. So it's about 4 people interchanging. It's not a permanent structure, but I think Mr. Soko will always be part of that intake criteria according to the manual.
And have you, in the team that you're responsible for, have you had a situation where the ID approaches your I call them juniors, someone not other than you, the head of the team, to look into a matter? Have you had that kind of situation?
I have never had that type of situation, commissioners, except for this case that we're dealing with, that I'm here for today, where one of the juniors in my group was utilized for these Mukweli Lushaba matters without my knowledge and engagement.
That's exactly what I wanted to ask about. So I'm going to pause for now.
That's the only one case. Otherwise,
okay, let me pause my question. We'll discuss it in more detail when we get to the specifics. Thank you.
Thank you.
You can proceed with
At
paragraph 20.
Paragraph 20, as a matter of practice, the groups do not share the detail of their respective matters with one another, and members sign non-disclosure undertakings. This is to guard against the leaking of information. Every matter is, however, headed by the DPPP, who acts as its project owner. If I can just add on to this, on paragraph 20, the signing of non-disclosure forms. This is drilled into each and every employee that comes in, the non-sharing of information. So when a group is dealing with a case, only that group knows the facts, who are the suspect. Documents are only dealt by that specific group. I cannot be involved in the discussions of another group where they should have met, unless if I am designated. There are cases where 2, even more, deputies are designated in one group. We do this because sometimes people go on leave. You have a deputy who's on leave and his group wants a Section 28 subpoena that has to go to the bank to be signed and on an urgent basis. Therefore, if I'm available, then I can sign that. But I can only do it if I've been designated to be part of that group. Otherwise, the non-disclosure requirement comes into place. So we don't share information. That is why a person who occupies an office next door to me can be involved in this case, which, for example, a case that involves my neighbor and I wouldn't know about it because we don't share. Even when we're having our coffee and discussing matters, we don't talk about cases. If I have a problem, if I want to know something, and when we're discussing about the law or issues, we talk in general terms. I'm not going to say, colleagues, please help me. I have this case of so and so, and how do I go about? I can give them a scenario without talking to the names of the suspects in my case, to avoid information being shared amongst.
Advocate Serunye, the last sentence of your paragraph 20. Good morning. I don't think I greeted
Yes.
you. Good
Thank you.
morning.
Morning, Commissioner.
Paragraph 20, the last sentence, you say every matter is headed by a DPP who acts as a project owner.
Indeed.
Are there exceptions to that rule, if it's a rule at all? Because the matter you're talking about next, as I understand your statement, it was not headed by a DDPP.
Yeah. There is no exception to that rule.
Or there should not be.
There
There should
shouldn't
not be exceptions.
There shouldn't be.
So where there are exceptions, what is the problem and what is the reason for that?
The only exception that I know of is with this case, and I cannot explain it. I always believed that each case is going to have or must have a DDPP, because there are functions that a DDPP must do as the investigation unfolds. As I indicated earlier, when we need information from the banks, from cell phone providers, and so on, we serve them with a subpoena. That subpoena can only be signed by a DDPP. And if a group does not have a DDPP, I cannot see how they are going to be able to proceed.
And
with
that's the whole
investigation.
point of a prosecutor-led investigation, that you need a senior prosecutor overseeing and guiding that investigation.
That is true, Commissioner. That is true.
So where that doesn't happen, what is the issue? What is the problem? I'm trying to understand. Because the case you're going to deal with, you're going to give us facts, but I'm more interested in reasons.
Yeah.
When no DDPP is appointed to head or to be a project owner of a matter, what could be the reason?
Commissioner, I find it difficult to explain. Because that shouldn't happen. That shouldn't happen. Otherwise, investigations are going to stall. They are going to find it difficult to get information from service providers. And in such a situation, you also don't have leadership. You don't have anyone guiding and helping the team, and so that they can wrap up. Everybody's going to do as they please. So that's why you need a leader in the form of a DDPP to help direct the team.
It's like a soccer team playing a match without a coach.
Indeed, Commissioner.
It can happen, but it shouldn't happen.
They are going to kick the ball all over without any direction. My involvement in the Mokwele matter, at paragraph 21, on the morning of 27 June 2005, I arrived at the office as usual, around about 7:30. On my way to my office, I found colleagues in one of the offices discussing an arrest which IDEC had conducted the previous day, which was the 26th of June 2025. This arrest was on a number of high-ranking police officers.
Just, I'm thinking once an IDEC matter reaches the stage of an arrest, there would surely have been some investigations already.
Indeed, Commissioner, you cannot
Within,
arrest without...
that is, investigations within IDEC itself.
That is what has to happen. You cannot arrest without doing investigations. You cannot arrest without coming to a decision that we've done so much work, we are ready, or we still have shortages here and here. So the team must meet and...
But we have enough to arrest.
We have enough to arrest.
Yes.
Yes.
Now, the way you frame it in this, in these two sentences, it appears you are not aware at all that there were any investigations, and not just investigations that ought to have led to the arrests you heard about this morning.
Yes. Chair, what I'm stating there, indeed, is I was not aware, but it's because this case was not in my group. I get to the office, and the office is buzzing with people talking about this big arrest that happened the previous day. That is what drew my attention to that. Everybody's talking about it. And
So it was not in your
it
group?
was not my case. It was not,
Okay,
I was
okay.
hearing about it for the first time.
In whose group was it?
I didn't know at the time, and that is what then made me curious as well, because everybody's talking about that case. I wanted to find out, as I'm stating by the next paragraph, I then started asking around, which case are you talking about? Who's the DPPP? I stayed on paragraph 22, commissioners. Consistent with the practice that I described above, I had no prior knowledge of this matter. Out of concern, I inquired which group was responsible for it. No one appeared to know, at least from the people that I was talking to, no one appeared to know which DDPP was responsible, which I found unusual, since every matter is headed by a DPPP as its project owner.
Advocate Sereni, before you move away, was it out of concern at that point, or was it interest? And if it's concern, why were you concerned at that point?
No, it was more out of interest. Everybody's talking about this case. It's generals in the police arrested, and naturally, as a leader myself in the structure, that draws me to a point of wanting to know which cases, who are handling this case, which cases, and that is what then leads me to paragraph 3, where as I'm inquiring, I'm then told that Advocate Joy Tlachuayo, who was one of our junior state advocates, and who was at the time reporting to me, or reporting to my group, and who, without belittling her or anything, she was amongst the most junior in the office. I'm told she's the one who's handling this case. I established that she was appearing.
Can I just, before we forget it, from your description or allocation of the 4 streams and the DDPPs that you allocated there, it seems that Advocate Paul Lowe would have been the DDPP responsible for this stream, because I think you said intelligence, he was responsible for that.
Indeed, Commissioner. If things were done in accordance with the manual,
Yes.
Advocate Lowe ought to have been the project owner, the DDPP in the case. But if I remember well, he was also there in the office that morning, and that is why he didn't appear to know anything about this case as well. And that is what was strange.
Yeah, another kink, as it were, would have been the fact that one of your prosecutors, Advocate Tlachuayo, was the prosecutor. You told us that if someone were to be taken from a deputy by another deputy, there would be a discussion between the deputies. Obviously, from what you say here, nobody had approached you and asked that Advocate Tlachuayo be part of the prosecution in another group or team. So, as I say, so that's another kink, or that's another anomaly.
Indeed, Commissioners.
And I also see the name of Mr. Brian Padiachi. Was he not a senior investigator in your team?
Padayashi was not in my team.
He was not in your team?
Yes, I think he was in the security cluster.
Someone else's team?
Yes.
So it looks like
But it was strange that a junior prosecutor was reporting to me is allocated to this case without me having been engaged. Not that it doesn't happen, like I said, I would have expected, say, maybe Advocate Paul Lowe, if he was part of that group, to have discussed the matter with me, to say, we need a prosecutor, we're having a shortage. Do you have a lot of work for Joy? If I said, no, then we agree, they can utilize it.
And was this the right team for, or rather, was this the right case for Mr. Padiachi? Or was he too misplaced, as it were?
He's a senior criminal investigator, Chair. I would believe he was suited to
No,
be part of this.
I'm asking in the context of the different groups. For example, Commissioner Baloyi said this was an intelligence matter which would have fallen under deputy law. So did Mr. Padiachi work under deputy law?
He was working under advocate law.
Oh,
So he was in the security cluster, which was headed by advocate law.
That's what I wanted
The
to
only amazing thing, Chair, is that advocate law appeared also not to know about this case, because I saw him in the office that morning.
Yes.
He was not properly dressed for court, or at least that he knew about the case.
So when you inquired, what case is this and what have these generals been arrested for? He too did not respond and say this is what happened and this is why they were arrested. He appeared to be in the dark as well.
He appeared to be in the dark like I was. He did not know about the case.
Advocate Sigurunye, ordinarily who allocates matters to junior prosecutors in the IDEC? So take, for example, Advocate Hlachwayo, who ordinarily allocates matters to prosecutors at A level. Is it the ID or is it the DDPPs?
It will be me. It will be me as the DPPP in that group. I would look at the setup of the team to say, I need, say, maybe one or two juniors. Let me go for Advocate Hlachwayo and so and so.
Can Mr. Sissoko allocate a matter to
No,
a junior prosecutor?
That doesn't fall within his mandate.
Ordinarily, only a DDPP would allocate a matter to a junior prosecutor.
That is true, Commissioner.
And
Only
if it's a junior prosecutor in your team, you would be the one allocating.
Indeed, so that is so, Commissioner.
I think you were to...
And in this case, that is why I found myself asking a lot of questions, because I didn't know about the case where one of my juniors is involved. And, but I understood that because we signed these non-disclosure forms, maybe that has happened and I was not involved. But it was something didn't sound right. It was a bit strange.
I think you were to start I established that she was appearing, or am I
Yes,
mistaken?
I then established that Advocate Hlachwayo was appearing in court that morning with investigating officer Mr. Brian Padayashi, and that there was no co-prosecutor with her in court, no senior state advocate, no DDPP, and no chief investigator assisting her. I was concerned that a matter of this magnitude, involving the arrest of senior members of the police, was being handled without such support and without a DDPP overseeing it. At that moment, yes, I then, together with one of my fellow DDPPs, Advocate Jacinta Vetboy, and Mr. Sibusi Sochikovi, who is the chief financial investigator. These people, I'm mentioning them because they were in this group when we were inquiring and making, and trying to find out who was handling this. We then decided, the three of us, we then decided to approach the head of the unit, the investigating director, Advocate Johnson, to request permission to attend court to assist Advocate Hlachwayo. On arriving at her office, we found that the investigating director had not yet arrived, and we left a message with her personal assistant, Ms. Innocent Sikukuni. On my way back to my office, Ms. Sikukuni telephoned me to say that she had discussed our request with the investigating director telephonically, and that the investigating director had agreed that we could attend court as requested.
Did you ask or did you find out who and how Ms. Hlachwayo came to be allocated? Who selected her?
Yes. I only came to know afterwards, commissioners. I asked and I was told, I asked and the information I got was that she was appointed by the ID. And I was told that initially the only prosecutor in the matter was Advocate Ramsemi, Drew Ramsemi, and that Hlachwayo was then also allocated, or at least designated to the matter around May, so earlier, just shortly before the arrest in this case. Paragraph 26, when we arrived, we were then given permission by the ID to go and assist in court. When we arrived at court, we found Advocate Tlhatjwayo in the company of the investigating officer, Mr. Padayashe, and evidently overwhelmed. The court was about to commence, and the J15, which is the administrative form to which the charge sheet is attached, had not been completed, there being some 7 accused involved in the matter. Advocate Vedboy obtained the necessary J15. I remember she literally rushed to the clerk of the court, brought a blank form. I then took the docket from Mr. Padayashe. I then started reading out the names of the accused as they appeared in the docket to Ms. Vedboy, who was then, to Advocate Vedboy, who was then completing the J15, which was then handed to the clerk to register the matter on the book. Our assistants enabled Advocate Tlhatjwayo to consult with the defense legal representatives. The courtroom was full of police officers, family members of the accused, and members of the press. Advocate Vedboy and Shikovi obtained seats at the back of the court. As there was nowhere else to sit, I then sat in front next to Advocate Tlhatjwayo, and Mr. Padayashe, the investigating officer, was seated directly behind us. I was not the prosecutor in the matter. My colleagues and I attended solely to support Advocate Tlhatjwayo. The proceedings commenced before the magistrate, Mr. Madlanga, whom I did not know and was seeing for the first time. Advocate Tlhatjwayo conducted the bail proceedings on behalf of the state, indicating that the state was not opposing bail and setting out the reasons. The legal representatives of the accused moved their bail applications by reading their client's supporting affidavit into the record. At various points, Advocate Tlhatjwayo experienced difficulty in answering questions from the court and conferred with me and with Mr. Padayashe, who was seated behind us. In the course of dealing with the bail application, Advocate Tlhatjwayo asked the court to impose a condition that the witnesses not be contacted or interviewed by the accused. The magistrate indicated that he required a list of the witnesses, as he could not simply warn them, and he appeared not to be satisfied with her response. The magistrate then invited me to address him, observing that I appeared to be from the same office. And maybe just to add here, Commissioner, I remember he precisely said, because they were engaging with Advocate Tlhatjwayo, and he then looked at me and he said, okay, let the gentleman seated next to you address me. He appears to be from your same office, because now and then Tlhatjwayo kept on talking to me and at the same time with Mr. Padayashe, and that is why the magistrate said, let this gentleman address me. Before doing so, I then asked Padayashe whether a bail statement or affidavit had been prepared.
What is a bail statement? What would you find in there?
Commissioners, this matter, as I understood at the time, fell under Schedule 5 of the Criminal Procedure Act. And Schedule 5 and Schedule 6, these are serious matters. Schedule 5, the accused to be released on bail has to bring an application and satisfy the court that it is in the interest of justice that he be released on bail. What we do as the state, to avoid the investigating officer to testify viva voce in court, he then compiles an affidavit setting out even if the state is not opposing, the reasons why we are not opposing. For example, we would have verified the addresses of the accused. The statement will state, we've checked their criminal records. They don't have criminal records. They are not a flight risk. They are gainfully employed, and all those kind of issues, they'll come into the statement. We either do that by way of an affidavit of the statement, or the IO has to go into the box, and as a prosecutor, I'll then have to lead him to cover all those aspects.
And you say that's something that happens as a matter of course with Schedule 5?
It has to happen. I know, Commissioner, that there are instances where the state is not opposing, even when the state is not opposing bail, and the prosecutor addresses the court from the bar saying, we're not opposing bail. I know of instances where the courts would have insisted at least on some form of evidence, formal evidence from the state, at least by way of an affidavit from the IO or so. And I do not have case law with me, but I know there's a case or two where the court would have also said, even when the state is not opposing bail, but the court is sitting, the court needs to be assisted by the two parties. And even when the state is not opposing bail, but you, as an officer of the court, you have to address the court, say why you are not, give this information to the court. So if you have compiled an affidavit, it's easier for the court. You read it into the records saying these are our reasons. And when the court evaluates whether or not the accused has met the onus of proving that it's in the interest of justice that he be released on bail, the court has the benefit of both the state and the applicant's evidence. But in this case, the bail application or the statement was not done, which was one of the things that made me realize that this team did not appear to have been ready for this bail application. I would have expected them to, because when we were in court, I then asked Brian, just before addressing the magistrate, I asked him, did you compile an affidavit? Because now I could see the magistrate was going to engage me. So I wanted to speak out of an affidavit, not just give the court information which I was not privy of. But I remember asking him about the issue of the list, and then quickly he said, no, we have other outstanding investigations against some of these people. So that is why we don't want the list of these people to be known, because if we list them, that's going to impact on our outstanding cases. And that is what I then delivered to the court when the court was asking Tlatrayo, why not the list? I'm at the paragraph where the magistrate invites me to address him, and before doing so, I then asked Padayashi whether a bail statement or affidavit had been prepared. It had not. Mr. Padayashi explained that the witnesses had been told that if they were contacted by the accused, they should immediately report to him, so that there was no danger in that regard, and that there was a further ongoing investigation involving the same accused. Such listing of the witnesses could disclose their identities and the existence of that other investigation. This is what I delivered to the court. On that...
Sorry, so where you say in line 1, 2, 3, 4, 5, there's a sentence that starts, so that there was no danger in that regard. It's preceded by where Padayachi explains to you that witnesses have been told that if they are contacted by accused, they should immediately report it to him. And then you say, so that there was no danger in that regard. Can you just explain what you're addressing there?
Yeah.
Where you say, so that there was no danger in that regard.
Yeah, I think what I wanted to say here was that Padayachi and his team would have discussed with the witness today, if anyone contacts you, please let us know so that they can take steps. So I'm saying, so that there was no danger in that regard. The quicker they are alerted, the investigating team is alerted, then the danger could be averted.
Okay.
On that basis, at paragraph 31, on that basis, I then addressed the court and requested that the witness not be listed, so as not to compromise the other ongoing investigations involving certain of the accused. Out of respect for the court, I could not decline to address the court when the magistrate invited me to do so. At 32, bail was fixed for the accused in the amount of 10,000 rand each, save for accused number 2, Mr. Lushaba, who was not admitted to bail at that stage owing to a separate outstanding matter, and the matter was postponed. Among the conditions imposed by the magistrate was a condition that the accused do not enter the premises of crime intelligence anywhere in the country. neither the state nor the investigating officer had requested that condition, and the magistrate gave no reasons for imposing it. Of significance is that in the course of granting bail, the magistrate himself remarked that he was not persuaded that the state had a strong case, and indicated that this was among the consideration that moved him to admit the accused to bail. He observed that the matter was not a typical fraud or corruption case. This doubt was expressed by the presiding officer at the very first appearance. It's there on record, Commissioner. The magistrate says it after asking Advocate Hlajwayo some questions. He says, I'm not that convinced that your case is that strong because it's not like the typical cases that we deal with of fraud. And he also says it to the accused when he grants them bail. He says one of the things that I've considered is this issue, and I'm not convinced about the strength of the state case as it stands, based on the address by the prosecutor. The record speaks for itself on that issue. 34, my involvement then ended after the first appearance.
Can I just ask, so you stayed in court the whole time until the court rose?
Indeed, Commissioners, I stayed in court until the matter was, the bail application was finalized.
And where was Mr. Padiachi by the time court rose?
Mr. Padayashi was with us up to a certain point, I think just before the judgment, because he had to catch a flight back to Durban, Port Elizabeth. He's based there, he stays there, so I think he comes to the office after every second week. There's an arrangement that they have in the office. So I remember he had to go back, rush to airport to catch a flight. So he kept on saying to us at the time, guys, I'm going to leave you. I'm not going to stay until. So he left at some point. When the magistrate was delivering judgment, he was no longer there, he left.
More specifically, when the debate or discussion about conditions was happening, do you recall whether he was in court or not?
He was still in court, because I also asked him, that's when I asked him, do you have a bail statement? Have you prepared a bail statement? And when Hlajwayo was addressing the court about the conditions, he was still there. I think he left just before the magistrate had started delivering judgment.
Thank you.
Yes.
Advocate Serene, before you move to the 8th to August, when you come back from court and having seen what you've seen that day, from the moment where you were consulting your colleagues to what you've then witnessed in court, did you do a report to either the ID or Mr. Sisoko on the developments of the day? In particular, your concerns.
Yeah. Personally, I did not, because at least at this stage, I did not have enough information that I later got. At least at this stage, in my mind, I'm thinking there's a team that is dealing with this case, but it's strange that only one prosecutor and one investigator are in court, and the DPP that I expected to be involved in this does not seem to know about this case, because he's not with them, and I saw him in the office. But, you know, and I could see that they were not ready. There was no bail statement. But after that, my involvement literally ended there. And what we do in the office, when I would have expected Advocate Hlajwayo to do the reporting to the ID. That is what we do when come back from court, especially in this type of cases. This was a very big case. I mean, generals in the intelligence service, you know, one would have expected a report to be given to the ID to say, this is how we fared, this is what happened, and the case has been postponed to such and such a case. Personally, I did not, at least at this stage, I did not make any report because I was not part of the case. My involvement was to help on that day, and I think I did my level best on that day, and that was the end of it.
Suppose the question is, I understand the report as it relates to what happened in court and where it landed, where bail was granted, conditions and all of that. But in this instance, what you knew that day was that there was no DD, there was no senior prosecutor, They certainly didn't appear to be ready for the bail proceedings. You had to step in as somebody who's completely not involved. This was run by the most junior prosecutor, you say, at the time. It seems to me that beyond the reporting about the progress of the case and what happened in court, there was other issues related to how the matter was being conducted that ought to have been reported.
True, but remember, I'm not, firstly, I'm not designated to the team formally in terms of the relevant provisions of Section 28. And secondly, we have these non-disclosure forms that we complete. So I cannot go beyond trying to find out even about the facts and getting myself involved that much. My request on the day to the ID was to be allowed to go and help in court, and that was granted. So I couldn't go beyond that unless I was designated formally into the case. You know.
But the concern is that you knew that there was no DDPP and there was no senior investigator, and that your junior prosecutor did not have sufficient support. That's why you had to step in at the last minute. Now, what you are saying here is after court, you left that there. So in other words, if there was going to be further appearances or further investigations, she would still be doing that unsupervised without a DDPP overseeing her work.
Commissioner, at the time, yes, but like I said, the name of Advocate Ramsemi also was thrown in. So somehow I know that she's also part of the case. I was told that morning she was off sick.
But she's not a DDPP.
No,
you said in paragraph 20 and I think 26 that the DDPP must head every matter and they are the project owner.
That's true.
So this matter was proceeding without a DDPP and a project owner. Because even if Advocate Ramsamy was assisting Advocate Tlachayo, it would be two junior prosecutors. Was that not a concern for you? For such a big matter, we're talking head of crime intelligence in the country and other generals at SAPS.
Commissioner Kumalo, it was a concern, and that is why I asked to go to court to assist. But I did not think of involving myself beyond that that point after the bail application was done, because I did not know why is this team so small. I did not know how it came about, but what I know is a case cannot be handled or done in the IDEC without the ID knowing. Therefore, I don't know how this team was composed, but honestly speaking, I didn't want to get myself involved in why was this done, why was not, because I was not part of the team at the time.
You give the impression that you did not want to step on the ID's toes. You did not want to ask her difficult questions. So you said, if she made the decision, I will live with it. I won't even question it. That's the impression you are giving me.
And I'll agree to that, Commissioner. Because as the head of the office, you would have made decisions. I can't ask questions on, especially questioning how this team was composed, why not involve me, or why not involving Advocate Polo, who was overseeing this. At the time, I didn't ask myself many questions on the composition of the team, but it didn't look right to me that a case of this magnitude was on the day of the arrest handled by a junior. I didn't take it further than that, but it didn't look right.
Sorry, you say in paragraph 34, your involvement ended after the court appearance, but I don't think you mean end, because in paragraph 35, you say you were called to a meeting on the 8th of August And at that meeting, the ID informed you that she had decided to include you in the matter. So it was not end forever.
That is correct, Chair.
So there was an intervening period during which you were not involved. That is after the court appearance in June. And then in August, you are brought in by the ID herself.
That is correct, Chair. I'm saying my involvement ended there with the bail application because I was not part of that team. I was not supposed to be part of the team. I went there and helped with the bail application, and my involvement in as far as they ended there.
Yes.
But
Only in
coincidentally, about 2 weeks after, then I'm called for a meeting where I'm formally then involved or designated by the ID into the matter. After the bail application, I did not work on this case. I did not discuss it. I continued with my work. I'm overseeing a group. I'm also having my own cases. I'm doing it. I concentrated on my work. I forgot about this case until on the 8th when I was called to a meeting by the ID.
The 8th of August.
On the 8th of August, and which is then on paragraph 35, on or about 8
Wait,
August.
maybe before you discuss, you go to paragraph 8, let me ask my question. And again, it goes back to wanting to understand the reporting and role of Mr. Sissoko. You have this experience now on the 27th of June, and you note all these wrong things about it. Isn't that typically something that would have had to go into the discussion? Because part of it sounds like resource allocation, right? Isn't that something that would have typically gone into the reporting to the, is it OMC or something, when you make those monthly reports and get it addressed there? Is that not?
I agree, Commissioner. It's something that ought to have been raised in that structure. I'm not sure if it was at the later stage, but from the date of the bail application when the case was postponed until up to the 8th, I don't remember. I don't think we had an OMC. But these are type of issues that are dealt with in the OMC. Resource requirements, where there's shortages, and even these challenges that how is the team dealing with such a big case and there's no deputy.
So you say you don't remember whether it was raised or that you had a meeting after that. Is that?
That is correct. Between the 27th when the case was in court and the 8th of August when I was involved in the case. But then from the moment I was involved, and the commission will see, as I'm calling meetings of this team, I'm also copying Mr. Salk. I'm involving him in the matter.
And where is Mr. Lowe in all of this by the time you get called on the 8th of August and you are now told this is your matter? Where is he?
He was never involved in the case at all, Commissioner. He was not part of this case at all.
Ever?
Even though the type of case resided in the group that he was overseeing, but he was never involved. He was not designated in this case.
Okay, thank you. And do you know why? Did you ever get an explanation, even informally, why you are the one that's been called on the 8th of August and he's not involved?
I did not ask why, but as I'm going through my statement, Commissioner, you'll see that I take it when I was called in, maybe it might have been the ID got, like I left a message with a PA, and she then gave a go ahead.
Okay.
Maybe because I helped on the first day, let me, I nearly said Somar, let me proceed with Sirunye because he helped on that day. I think
you could have said Somar, we've had worse.
Yes. So I believe she involved me and not him because I went to help on the first day. And because when she called me on the 8th, she said, I've decided to involve a DDPP in the case, and I want you to be part of it.
Okay, thank you.
Yeah.
All right.
Just to correct you on the intervening period, you said that after the court appearance, you were not involved until the 8th of August 2025, when you were called to a meeting and told that you would be included in the matter. The court appearance was on 27 June.
27 June.
Yes, 2025.
I'm very sorry,
You said,
Commissioner.
you said the intervening period was 2 weeks, so it was over a month.
It was over a month.
Yeah.
I'm thinking the appearance was on the 27th of July. It was actually on the 27th of June.
Yes,
Yes,
all right.
that is correct.
And just to add an important fact, it may or may not be relevant. Between the court appearance and the 8th of August, 6 July happened.
Indeed, Commissioner, the address to the nation by the general, is he a general? By, yeah, Mr. Mkwanazi, that happened. And that was in July. That was in July, yes. That happened, and I must say, I remember watching, I was home that Sunday, I remember watching the press conference as he was briefing, and then he mentioned this case. And I thought, how come? I didn't really, you know, I thought, you know, for the moment that I was in court and left the court, much as I didn't know what happened before, I didn't see anything sinister that when he mentioned the case and how it was handled, and that to be honest, I doubted his remarks at the time. To put it bluntly, I doubted his remarks at the time about this case, and for the longest of time I did. And until now, recently, in the last maybe 2-3 weeks of the evidence that we had in this commission, that's when I started realizing maybe, and I said it to one of our colleagues even this morning when we were having tea, that it appears I sort of found myself in an offside position, or at least handled a ball with my hands. In fact, I sort of feel a little bit angry if I think about it, that it feels like I was set up, not only me, but Hlachwayo as well. I think junior as she was, I don't think she was supposed to have been involved in this case. And looking at it now, it appears to me she was set up.
But I think you are being unfair to yourself. You are still going to come to this later in your statement. You have placed before us an annexure in which you actually questioned the merits of the case, and you prepared quite a lengthy document raising a number of concerns that you had about the merits of the case itself. Of course, I'm sure that what you are talking about now is possible impropriety with regard to why the case was investigated in the first place. I'm sure that's what you are talking about. But it's not as if you just gobbled up everything, every and anything that was placed in front of you.
Indeed, Commissioner.
Chair, I see the time, and we are about to go into his involvement. It might be an opportune time to take the tea adjournment.
Let's adjourn and resume at 11:30. Yes, Ms. Bowe.
Thank you, Chair. Chair, for the next couple of paragraphs, the witness goes into their involvement in the two matters, and you will note that there's a few annexures where he would have emailed the team or the ID regarding challenges that he had in relation to the matters. We do go into some detail on those at a later part in the statement. So he will read through those paragraphs and we'll go into detail on the content of those concerns a little later, not much later, a little later in the statement. Advocate Sirunya, we are now at the 8th of August 2025 when you are called into a meeting with the ID to get involved formally into the matter.
Thank you. Yes. On 8th of August 2025, the investigating director convened a short meeting and informed me that she had decided to include me in the matter. And that meeting was attended by myself and Advocate Drew Ramsemi and the ID. It was only the three of us. She asked me to oversee the two matters, the Lushaba matter and the Kumalo and others, in brackets Mokwele matter, with Advocate Dushanta Ramsemi as remaining the lead prosecutor in the Lushaba matter and Advocate Lachwayo remaining the lead in the Mokwele matter. She further asked me to attend to an anticipated bail amendment application under Section 63 of the Criminal Procedure Act in circumstances where Senior Counsel Advocate Mushololo was said to be coming on board, and she wished a senior person to deal with the matter. Yes.
Is Advocate Mshololo senior counsel? Or do you mean a senior junior?
No, yes. I don't know if she's a senior counsel, but in the words of Advocate Johnson, she said, Sirunya, I've heard that Advocate Mshololo is coming on board to represent the accused in the Section 63 bail amendment application. I therefore want somebody senior in my office so that they can match her. But I think at the time she was of the view that Lachwayo couldn't,
No, I'm raising it because senior counsel is a term of art and...
where defense, senior defense...
Yeah, and I think even though I don't really follow the proceedings in the case where she's appearing, I think her robes are the robes of junior counsel.
I appreciate that,
All right.
Commissioner. Yes.
Please continue.
Before you go on to the next paragraph, on this bail issue, because the issue was raised with Ms. Johnson, was it your now that you're on board from August, at this point, did you come to understand that Ms. Johnson knew that the bail condition that was imposed was not asked for?
Commissioner, I did not know at the time. Like I indicated earlier, I would have expected the prosecutor, Advocate Lachwayo, after the bail application, to give a report to Advocate Johnson. Therefore, I did not know how much she knew of what happened in court on that day and what she did not know. But as she's saying to me in that meeting, I'm bringing you in to oversee the two teams, the two cases, but also to attend to the Section 63 bail amendment. That is the specific instruction I'm getting to attend to the 63 amendment. My role was going to be that, but I didn't know how much she knew and whether the condition had been asked for or not. I think.
Thank you.
But as she's saying to me, Counsel, as she's saying to me, prepare for the bail amendment application. My understanding at the time would be in whatever application is coming up, I must have a look into that, prepare for that thoroughly, since there's somebody senior also defending the accused in that application.
Advocate Sirunya, in this meeting, were you being asked to take overall oversight of the matter? I know you specifically mentioned that you were asked to take over the bail amendment application, but did this extend to complete oversight of the two matters?
Indeed, it extended to overseeing the two cases, the Mokwele/Khumalo matter and the Lushaba matter. But with the two colleagues remaining as lead prosecutors, Advocate Ramsemi to lead the Lushaba case and Tlashwayo to lead the Khumalo-Mokwele matter. So I was coming in as a supervisor. Remember now it's clear to me there's no DDPP appointed into the matter, so I'm coming in after the fact as a DDPP to oversee the two cases.
Now, you had expressed a concern earlier that when you found out that it was Advocate Tlashwayo who was lead on the matter, that she was junior, this was a big matter involving generals and all of that. Did you express this view in that meeting when you were being told that she would remain as the lead prosecutor in this matter?
No, I did not raise it, commissioners. It was a short meeting. Sirwinya decided to include you as a DDPP on this matter to oversee it. I didn't. It was a very short meeting, being told what to do, and it was the end of the meeting.
So you considered it more of an instruction and less of a consultation?
It was an instruction more than anything.
Okay, thank you. You can continue.
Right. After this meeting at 36, because of the instruction to oversee the case, I then proceeded to request the docket and the Section 27 referral to familiarize myself with the two matters, because now I'm told these matters came via a 27 referral. So I remember talking to the investigating officers and to the prosecutors to say, please give me the docket. I want to start reading these dockets. This would have been in preparation, especially for the impending Section 63 bail amendment. On 16, I think the docket were given to, the dockets were given to me on the 13th of August. I'm continuing to read from the statement, line 2. On 16 August 2025, which, commissioners, was a Saturday, I decided, let me go to the office. I want to read these dockets and so that I can prepare thoroughly for the application. I read the docket for the first time. When I'm saying docket here, I'm referring to the Mokwele/Khumalo docket. It consisted of 4 volumes. Having done so, I then issued a trial preparation note to the team. I read it and finished it that Saturday. And I issued a trial preparation note to the team, together with an attachment setting out a series of questions and concerns. I then forwarded the email to Ms. Kukuni, who's the personal assistant of the ID. And this email and attachment attached to my affidavit as PS3. I deal with the substance of those concerns below. The investigating team.
Sir, you asked for the Section 27 referral. Did you receive it?
It was never given to me, Commissioner Baloyi. It was not given to me. I asked for it. I spoke with Mr. Brian Parayashe on about 3-4 occasions. And every time when I was asking for that, he couldn't give it to me. I don't think he had it, because he would say, okay, Advocate Peter, I'll come back to you about it. And up to about 31st of October, I was still asking for, I'm saying 31st of October because I remember when I'm checking my emails, I can see on that day I raised the issue again with Mr. Sisoko. I said the accused have asked for further particulars, and one of the issues that they are raising there is they want to be provided with a Section 27 referral. I'm still looking for this document. Do you perhaps have it? I was then raising the issue with Mr. Sisoko. It was on 31 October. So from August, I was looking for that document, but no one could give it to me. I spoke to the prosecutors. I was getting, Tlashwayo did not know about it at all. She said she hasn't seen it. Advocate Ramsemi said she saw it, I think in the earlier part of the case when they were starting the investigations, but it appears either it was lost or disappeared. I remember she couldn't also give me a copy of that. She said she gave it back to the ID, But it appears the ID was also looking for it from her, so I don't know whether it was lost,
Did
or
she,
at least up to that stage.
yes, Ms. Ramsame, when you ask her or when you discuss with her the section 27 and you ask for it, did she express anything about its contents, the one that she has seen? Did she express any concerns whatsoever relating to the section 27 and the charges?
No, she did not. She did not.
Thank you.
Thank you.
Advocate Serunya, several times now you keep referring to Ms. Ramsamy as true. When we read the transcript 2 months from now, we're going to have a problem. So I'm going to suggest that you use the surname. I know you are used to
Yes.
how you speak to her in the office, but just for our benefit.
I'm very sorry about that, Commissioner. Yes.
Just before you continue, for completeness, Commissioner Baloyi, the email in referenced is at page 101, and that would have been sent on the 31st of October to Mr. Sissoko, where Mr. Advocate Serunye was indicating that one of the accused is seeking further particulars and needed to see the Section 27 referral. Is that what you were referring to?
Indeed, it's on which annexure?
It's annexure 10.1 at page 101 of the annexures.
Indeed, Commissioners, on annexure 10.1, on the 31st of October at 12:20, I sent an email to Mr. Sissoko. I copied the project manager, Mr. Tsepo Tlale, Advocate Ramsemi, Advocate Tlachwayo, Mr. Padayashe, and Chief Daylan Perumal, with the subject Human and others. Good afternoon, Mr. Soko. We are in the process of answering the request for further particulars received from General Lushaba, accused 2. The defense wants to know how the IDEC got involved in the investigation of this matter, whether it was a Section 28 or 27 or 28 referral, and who referred it to the IDEC. In brackets, proof of such referral is needed. Do we have a Section 27 referral in this matter? And if so, where do we get a copy of same? Was it by way of a letter, as we hear from the evidence presented at the ad hoc committee, or by way of an affidavit? And I must say, Commissioners, I did not receive a response to this email from Mr. Soko and or from any of the colleagues who are copied on the email.
This is October, but you say you asked for it immediately after you had been brought on board, so this would have been in August already.
From the moment I was brought in on 8 August, I started asking for these documents and the docket, and by 31 October, I'm still looking for that Section 27.
Did you ever ask for it from the ID, Advocate Johnson, directly?
I did not ask it from the ID chair, but what happened is, as I was asking the investigating officers, I think somebody informed her that I'm asking this many questions about the Section 27, and I think I'm dealing with it on the affidavit. There's a stage where the ID called us to a meeting, me, Advocate Ramsey, and Advocate Tlachwayo. It was also a very short meeting. It was about during lunchtime, and when we got into the boardroom, she was already seated there. She looked very angry, I must say, and immediately when we sat down and she addressed me, the meeting was about her addressing me. She said, Sirunya, here you are looking for a 27, you're asking many questions. Don't you believe my investigators? And she said, I have seen the 27. The ID has seen the 27. What more do you want? And I said, but ID, I'm the designated DDPP in the case. And I'm told this case came via referral. I want to see this document. And the accused are also asking for it as part of the disclosure or application for further particulars. And she said, no, guys, go back and work. The ID has seen this document. Okay. So that was the end of the meeting.
Chair, Commissioners, this is explained at paragraph 63 of the statement.
Perhaps let's not go there, let's come back here.
Yes.
Yes.
Advocate Serunye, you can proceed.
Thank you. At 37, remember now, on the 16th of August, the Saturday, 16th August, I sent an email to the team members with an attachment having a number of queries that I was raising. And at 37, paragraph 37, the investigating team then responded to my questions. And I also in turn replied. My questions and their responses were in blue to my email, annexed as PS4, and my reply is on 17 August 2025, annexed as PS5. In the course of discharging my responsibilities for the matter, and in an attempt to address the difficulties with the charge sheet described below, I settled an amended charge sheet. The amended charge sheet reduced the matter to 2 counts, including a count of conspiracy under Section 21 of the Prevention and Combating of Corrupt Activities Act 12/2004, commonly referred to as PRECA, and I attached in my affidavit as PS6 the charge sheet which I settled.
Before you proceed, maybe Ms. Bowe, are you planning to come back to these annexures and deal with them? I mean, I'm looking at annexure PS3. What is attached seems to be an important document that the witness is speaking to. I'm assuming the following. What's the
Commissioner
intention?
Baloyi, at the section that deals, at page 13, you'll see there's a section that deals with the concerns regarding the Mukwele matter. It will be followed by another section dealing with the concerns raised around the charge sheet, and then concerns around the Lushaba matter. It is the contents of those annexures.
Okay, thank you.
Advocate Serunye, you can continue.
Paragraph 39. In or about September 2025, during a postponement held in the magistrate's chambers, the accused were brought closer to the table. I must say, the court building was under, there was some construction going on in the building at the time, and most of the courts were waterlogged, and therefore we couldn't sit in the courts. And Mr. Madlanga called us to his office, and that is where the matter was then postponed in his office. And on line 2, I then recognized accused number 4 on that day. I recognized accused number 4. Accused number 4 is Mr. Lekalakala. I recognized accused number 4 as a person known to me. We come from the same township and had played soccer together, a fact I had not previously appreciated. I consider that this personal association precluded my continued involvement in the matter, and I submitted a memorandum to the investigating director requesting to be recused from the matter. Commissioners, at the time when I was compiling the affidavit and signed it with the evidence leaders, I couldn't locate the said memorandum. I have, however, managed to locate it, and I gave a copy to the advocates this morning, the memo that I prepared and forwarded to the ID. I don't remember getting a signed memo from the ID, so I gave them the memo that I prepared, which I gave to one of our admin personnel to hand over to the ID. I have, however, at the time, I only annexed as PS7 an email communication, which I sent to the head of investigations and operations, which she was confirming that my memo was submitted to the ID. Maybe just to explain here, I wrote a memo, sent it to one of our PAs at the time, Ms. Dikeledi, I don't remember her surname. She then took it to Mr. Sisoko. So when I was preparing, at a later stage, about 3 days or so, I then sent an email to Mr. Sisoko because I was not getting any feedback from the ID. I asked if my memo asking him to be recused from the matter had been submitted to the ID. And Mr. Sisoko confirmed in that email, PS7, that yes, I have submitted your memo to the ID, and she's attending to an ESCO meeting. She said she'll deal with the matter when she comes back. At paragraph, yeah.
Just one moment. Commissioners, the document that was just handed up is the email and the original memo prepared by Advocate Serunye. We've marked it Annexure 7.1 because it's associated with that paragraph. And the email the witness was referring to Mr. Sissoko can be found at page 74 of the annexures. It is the email at the bottom wherein he was asking, my apologies, his email, the original email is on page 75, so we'll have to work up. You'll see there's an email from P. Serunye to Sinyani, wherein he indicates that he handed over a memo addressed to ID and Mr. Sissoko, notifying them of his recusal, and he explains there how he knows the accused. And then Mr. Sissoko responds on the next page, not the next page, the previous page, at page 74, where he confirms that the memo had been brought to his attention and he had brought the memo to the ID's attention, but that she was attending a meeting. Yes, you can continue.
Can I quickly read the memo into the record, Council?
Yes.
That is Annexure 7.1. Okay. I wrote this memo then on the 16th of September. I then emailed it to, as per page 1 of the badge. You'll see I then emailed it to the admin personnel, Sinyani, Manchidi, with the subject recusal from the matter of State versus General Kumalo and others. Attachments, it appears I wrote that email on top of I wrote the memo on top of another document. That is why the attachment appears with the subject Estina request to NDPP. So I worked on top of another memo. Right. On page 1, the memo is directed to Advocate Johnson, Investigating Director, and to Mr. Sissoko, Head of Operations and Investigations, from Advocate P. Serunye, Deputy Director of Public Prosecutions. Subject, recusal as prosecutor in the matter of State versus General Kumalo and others. The memo is dated 16 September 2025. Paragraph A, purpose 1. The purpose of this memorandum is to inform the Investigating Director and IDEC Head of Operations and Investigations of my recusal from the aforesaid matter. Background. About 4 weeks ago, the ID formally authorized me to be part of the prosecution team in the matter of State versus General Kumalo and others. The matter was already on the court roll, having been first enrolled on 27 July 2025. And it seems on the email I'm repeating the same mistake of date of 27 July. It actually should read 27 June 2025. In August, the matter was remanded to 8 September 2025 for a formal application in terms of Section 63 of the CPA Act, brought by accused 1, 3, 4, and 7. On 8 September 2025, I presented the state's case, assisted by Advocate Joy Tlatwayo. The application commenced on that day, but not finalized. The matter was remanded to 15 September 2025 for continuation. On 15 September 2025, the matter could not proceed due to the fact that the Magistrate Court building was waterlogged and some of the courtrooms did not have electricity. The matter was then postponed in Chief Magistrate's office in chambers. The accused were called into the said office and stood behind us, in bracket, us referring to the lawyers, facing towards the magistrate. Accused 4 was standing closest to me. When I turned back to look at the accused, I then noticed, for the first time since the first appearance, that accused 4 is the person that is known to me. Accused 4 and I grew up together in the township in Mabopane. We actually played soccer together for many years, albeit for different teams. For all intents and purposes, accused 4, in brackets, Josias, as we used to call him, and I are homeboys. Between yesterday and this morning, I have verified that accused 4 is the same person I grew up with. Thus, I have formally decided to inform IDEC management and recuse myself from handling any case in which Mr. Josias Lekalakala and his family members, in brackets, and associates, are accused persons. I have already disclosed this fact to my fellow IDEC managers in an earlier management meeting held this morning. Conclusion, to avoid any negative perceptions and in the interest of justice, I'm formally recusing myself from this matter and any matter that may involve family members and or associates of Mr. J. Lekalakala. On 29 September 2025, I'm formally going to recuse myself in court before the magistrate since I was still addressing the court when the matter was adjourned on the last occasion. I did not recognize Mr. Lekalakala in court on the 3 previous occasions. Otherwise, I would not have been part of the prosecution team right from the onset. Whilst I was part of the case, I prosecuted it to the best of my ability, and the record of the proceedings will bear testimony to that fact. I just do not want any wrong perceptions to be created by my continued prosecution of somebody that I grew up with. My name and integrity mean a lot to me, so are the interests of justice. This memo you'll see it was dated 16 and addressed to Mr. Soko and Advocate Johnson. As I indicated, Commissioners, I tried to locate the signed copy, I couldn't find it, but it is backed up by the email PS7, where Mr. Soko confirms that the memo was brought to my attention, referring to himself, Mr. Soko, and I have also brought it to the attention of the ID. However, because she's attending MENCO, and I was also on leave yesterday, we are only going to discuss it tomorrow when she's in the office. But what followed on this, if I go back to my affidavit, on paragraph 40, approximately 2 weeks after I had submitted this memo, 2 weeks later, the investigating directorate informed me, the investigating director informed me that she had considered my request and granted it, but asked that I first complete the Section 63 bail application before withdrawing from the matter. I remember that day it was me and the ID and Mr. Soko. I was called into her office and she said, I received your memo and it's only fair that you recuse yourself from the case because you cannot prosecute a person that you know and his colleagues and associates. But she said, but because the bail amendment application has already commenced and it was almost halfway, please finalize that and then you can then formally withdraw from the matter. And that is how then I proceeded, at least with that application. On or about 14
Advocate
October.
Serunya, do you know if anyone then replaced you as the DD after your recusal was accepted?
Yes. Advocate Manilal, his name is Santos Manilal, replaced me. It's him and a number of prosecutors, I think 2 or 3 other prosecutors, Advocate Isaac Duploy, and Advocate Bastian Thienasen. I think that's the surname. I'm sorry if I'm not pronouncing his surname properly. But they were only, yes, they came on board. I don't know at what stage, but as that period, I proceeded to finalize the 63-hour and the bail appeal that followed later. But I know that they were later then involved with Advocate Santos Manilal being the DDPP and project owner of this case. When I ceased to be the prosecutor in the case, I think so was Advocate Ramsemi and Advocate Tlachwayo. So the team led by Advocate Manilal took over the 2 cases. And I think they're still the prosecutors.
You say the team without, it's a new team without, new, in that it now doesn't have Advocate Ramsame and Advocate Tlachwayo.
That is correct, Commissioners.
Okay.
The team of Advocate Manilal took over the two cases. And Advocate Ramsemi ceased to be the prosecutor in the Lushaba case. So did Advocate Tlachwayo.
Okay.
I don't know at what stage they were told to no longer be part of the case, but I know for a fact they are no longer part of the 2 cases.
All right. Maybe just correct my assumption or what I thought things meant. When you were setting out the 4 different streams that you have, each one of them led by a DDPP. I assumed that therefore there's only 4 DDPPs in IDEC. You now make a reference to Advocate Manilal
That's correct.
as a DDPP.
Yes.
So does that mean you have more than just the 4, and where do they fit in these different streams that you have?
No. Commissioner Baloyi, at the time when the streams were set up, Advocate Manilal was still a senior state advocate. He was not yet a DDPP. And he was reporting to one of the DDPP's, Advocate Vetboy. And he only later became a DDPP. I think he went for interviews at some point for the position and was then appointed formally as a DDPP and became part of the DDPPs. And at that stage, then it would have been me and Advocate Manilal, Low, and Advocate Vetboy, even though Vetboy, her position was on contract, which ended last year in December 2025. And there was Advocate Annemari Friedman. So at some point we were 5 with the appointment of Advocate Manilal as a DDPP. We then became 5.
So when Advocate Manilal gets appointed, you say he gets promoted, he becomes a DDPP.
Yes.
When he gets appointed to replace you in these matters, DDPP law is again overlooked. He's also again not part of it. He's not the default.
He's like, yeah, that is correct, even though the case fell
Falls under his team, his stream.
Under his stream.
Okay. Thank you.
Thank you. On or about 14 October 2025, I'm reading from paragraph 41, when the matter was due to proceed, the magistrate recused himself on the basis that he had been subpoenaed by the commission. I was of the view that the reason given was not legally sound, and after consulting the team and investigating director, it's supposed to mean we, because I was not doing it for myself, but for the team, I launched an application to review the recusal. We consulted with the ID, we informed her about the recusal, and that the magistrate, the reasons that he gave were not in line with the established principle of recusal with reference to the decided cases, and therefore the unit then decided we then took up his decision on review to say, in line with decided cases, at least you ought to have had us, engage us, but in any event, the reasons that he was giving were falling short of the established principles, and that is why we took the matter up on review.
But that same consideration that he didn't give you the opportunity to address him when he decided to recuse himself, why was that not your consideration on the bail issue? Because in the bail issue, he didn't give the accused, we later learned in the appeal, that the accused were not given the opportunity to address him on that condition. I'm not probing at this stage, it's because you've touched on it, but it is a subject of interest that I would like to hear you on, not necessarily now in full.
Yes.
But it's something that I would like to engage you on.
I understand that. Can I quickly just take out a copy of my book here just to make... Commissioner Baloyi, when the reason for that was, and we looked at the provisions of Section 60 of the Criminal Procedure Act. Especially at 60, subsection 12, if I'm not mistaken, I want to go there. Section 60, subsection 12, the court may make the release of an accused on bail subject to conditions which, in the court's opinion, are in the interest of justice. And Section 60 says the magistrate must weigh up the facts presented before him and the evidence before him. And at the time, even though neither of the parties had addressed him on this specific issue or condition, but our understanding was that he has the powers in terms of Section 60, subsection 12, to impose any conditions which, in his opinion, were in the interest of justice, allowing him to release the accused on bail. We objected to the appeal on those grounds, but when one reads the record of the matter at the High Court on appeal, and the presiding judge took me on that, and I had to concede, commissioners, that yes, much as I didn't know much about the case on the day of the bail application, I was seated there, but I remember that my fellow prosecutor, Advocate Klatshwayo, was not engaged by the magistrate, neither were the defense, before the magistrate decided on this condition. And for that, that's the first point. But secondly, the magistrate did not give reasons for imposing this condition. And I think those two factors are what swayed the decision in favor of the defense, the High Court saying, when reasons are not given, it's difficult for a party to the proceedings to know why a decision was made against them, and there's a constitutional case to that effect. And furthermore, the fact that you are not engaged to address the court on that was also wrong, and that led to the conditions being set aside. On hindsight, yes, we ought not to have opposed it on those bases, but at the time you're looking at the Act, it says there's nothing wrong that the magistrate did. He has the powers in terms of 6012 to impose any conditions. Had he given reasons, had he engaged us to address him, that condition would have stood.
Okay. We'll come back to it, Mr. Srinya, and because Ms. Johnson did testify to this, specific questions were asked of her about this, and she had certain answers and explanations. So I would like to hear your views about it, but we'll get to it.
Thanks, Commissioner.
Thanks, Ms. Paul.
Thank you.
Thank you.
Paragraph 42, the accused thereafter abandoned the Section 63 application. That is now, after the magistrate had recused himself, the chief magistrate was trying to arrange another magistrate to take over the 63 application. And the accused then, because of that delay, they then brought a Section 65 bail appeal, Section 65 of the Criminal Procedure Act bail appeal. We again had a discussed with our boss, and we're given a go-ahead to oppose the application. And both matters served before the High Court, and the judgments are attached as PS8. The judgment for the bail appeal and the order for the recusal is PS9. In the bail appeal, PS8, the High Court agreed that the presiding magistrate's decision to impose the decision without engaging the parties and giving reasons was wrong in law and therefore ought to be set aside. On PS9, in relation to the recusal of the magistrate, the High Court ordered in our favor to say, yes, the magistrate ought not to have recused himself for those reasons given, not engaging you, and the reason given is also not in line with your rugby union matter. The bail appeal succeeded.
Sirinya, just before you proceed with the next paragraph, in practical terms, you would have had a conversation about the bail amendment application, the 63. Did you have a similar consultation with the ID regarding now the bail appeal? And did she give positive permission or consent for you to proceed with appealing? I mean, opposing the appeal?
We did, Commissioners, and we informed the ID, and then she gave us permission to go ahead with the opposition on the Section 65.
And when you do that, does she have sight of any of the affidavits that are filed, particularly in opposition?
She does, Commissioners, and I must say, everything that we were doing, we were sending to the ID. The Section 63 bail amendment application, all the affidavits of the accused were sent to the ID, and our responding affidavit of Mr. Brian Badayashi was sent to the ID, and the defense then asked for a postponement in that Section 63 bail amendment application. They then, on the next date, submitted an affidavit by General Masemola in support of their application, indicating that he had lifted their relocation to other offices. And that affidavit as well was given to the ID. I remember sending an email to the ID asking her that we want to, after receiving this affidavit of General Masemola, we want to respond. Now, how do we do it? Do we subpoena information from General Masemola, or do we serve them with a 28? My question to her was, do we do it by way of a 28 or by way of a letter under your signature being the ID? And she sends me an email to say, serve a 28, which is what we did, and we got further information, which then allowed us to prepare additional affidavits of 2 other officials, which affidavits we then also handed in support of our opposition. So she was kept abreast at all times of what was happening.
And do you recall whether Mr. Parayachi's affidavit in opposition dealt with that specific bail condition related to whether or not you sought that condition to begin with?
What's the question again?
Do you recall whether Mr. Parayachi's affidavit in opposition set out that or indicated that this bail condition was never sought or anything related to that?
You mean the affidavit which was filed
In opposition
in opposition?
of the bail appeal?
I cannot recall, but if I check on my emails, maybe those can juggle my mind.
All right, thank you.
Yes.
You can proceed to paragraph 43.
Yes. The bail appeal succeeded while I contended that the magistrate was in law entitled to impose the condition. Okay. While I contended that the magistrate was in law entitled to impose the condition, I was constrained to concede that he had failed to give any reasons for imposing the crime intelligence entry condition. And it was on that basis, that is the failure to furnish reasons, that the condition was set aside as irregular. The review of the magistrate recusal also succeeded, the court holding that the reasons he had given for recusing himself were not in accordance with established principles. At 44, having completed the Section 65 bail appeal and the review, I had no further involvement in the matter. Paragraph reading my concerns regarding the Mokwele matter. Once I was officially involved in the Mokwele matter, Advocate Tlachwayo and Ramsemi came to me to voice their concerns about the lack of evidence in the Mokwele matter. This is as way back now as 8 August when I became involved. Since there had been no DDPP on the matter before my involvement, I could understand why they felt that they could not address these issues directly with Advocate Johnson due to the power dynamic. Having read the docket on 16 August 2025, I was not satisfied that the corruption charge was sustainable on the available evidence and current formulation of the charge sheet. And as I said, and I said so in writing at the time, my concerns were not the product of hindsight. I recorded them contemporaneously. At the time, 16 August, that Saturday, I produced those queries, and I raised a number of questions. I remember one of my questions to them is, why were these generals arrested? And I couldn't understand. Or why are they charged with corruption?
Before we deal with your specific concerns, just one aspect here where you say that since there had been no DDPP on this matter before my involvement, I could understand why they felt they could not address these issues directly with Advocate Johnson due to power dynamics. What do you mean by power dynamics?
Yeah. Look, the two colleagues are juniors, and it's not easy for, it would not have been easy for them to go straight to the ID to raise issues. I'm talking about issues that they were raising with me. They had a lot of complaints that the investigators were not listening to them. They were not carrying out the instructions that, as they were delivering to them. It appeared to me, in fact, the relationship was not that good between the investigators, especially Brian Parayashi and Advocate Ramsemi. They were not in speaking terms when I came into the team. So I tried to put them together. In some of my emails, I'm saying to them, look, we're playing for the same team. Let's have meetings. Let's talk. Let's iron out whatever problems that we're having. So they couldn't. The two juniors couldn't approach Advocate Johnson, and that is why maybe they felt at ease to come to me and make all those complaints, relate them to me. Not that it was easy for me as well to approach Advocate Johnson. I respect her a lot. I've known her for many years, and I view her as my senior, and therefore I couldn't just barge into her office and say, but what's happening here? Why did you arrest these people? Why this? Why? That is why I put it in an email. I raised all my queries in an email, and I forwarded it to my colleagues. Then I forwarded to her via her PA. And it was not only this one email. You'll see, I think I sent about 2 or 3 where I was saying there's a problem with this case. The way it was investigated, it was rushed. I remember I sent an email directly to her, and I said, it appears this case was rushed, if anything. There might be a case of fraud or there, but the way the investigations were done were just not on with me.
Just before you continue to your specific concerns, when you say that it was difficult to approach Advocate Johnson, was it purely because of her seniority, or was there something in her management style that made it difficult to approach her?
Yeah. Look, I don't want to sound otherwise now, but yes, management style as well as in, she could be unpredictable at times, you know, and you know, she's a very good manager, make no mistake. For as long as she was in the IDEC, that organization, and even now, I mean, we headless as it is for the last week. She resigned last week, Monday, but the organization is continues running itself. It's like a steam train which is on the track. It's all because of the good work that she's put in. You know, the discipline is there amongst the colleagues. So she's done so much work that even when we're not having an acting head or permanent head, the organization can continue to run itself with the help of, obviously, the CEO, Mr. Sissoko, and the 3 deputies that are there. So I think it was more because of fear that how is she going to react, you know, when we take these issues to her, which was also the same, I mean, for me, at the level of a DDPP. Not that I couldn't raise issues with her, but you don't know how it's going to end. I referred earlier to a meeting where she was angry with me for raising the issue of a Section 27. So she told me straight in front of the 2 juniors, why are you making an issue about this? go and work? Why, I've seen the document, why do you keep on questioning or second guessing your investigators? So that is what I refer to here.
So in a sense that she, on the one hand, like you said, she's a good manager, but on the other, if you were raising concerns and questioning her decisions, she didn't take kindly.
She didn't take kindly to that, and yes, and she'll tell you straight. So
Were there many instances of this, or was this the only instance? The one instance relating to the Section 27 referral?
to me, Chair, it was only that one instance of the 27. Like I said, I've known Advocate Johnson for many years, and we've had, even though we never worked in the same office, but we've always had a very cordial and good relationship when we met in conferences and so on. And I've known her to be a very good prosecutor, hard worker, and when she came in as a manager at IDEC, the management was, for me, of a very high level.
Thank you.
Yes.
Thank you.
At 46, in my first trial preparation note, I raised, among others, the following questions to the team, but all these are covered in my email. 46.1.
Perhaps, as opposed to reading the summary, we can go to the actual annexure. If we can go to PS3,
Okay.
you'll see it starts with the email,
With the email.
that you sent to Ms. Sekukuni, who is the PA to the ID, where you brought this memo to her attention. And then below that would have been the email you sent to the team members, wherein you gave them Saturday homework while you went and watched a nice game, I see. And then the next page, on page 25, would be where you deal with your concerns. Can we go there?
Yes, Council, you'll see, I agree. You'll see at page 24, it's my email. Actually, the first email will be the last one.
Yes.
You'll see I sent it at 2:51 on the Saturday to the team members, Advocate Tlajwayo, Advocate Ramsemi, Mr. Brian Padayashe, Chief Investigator Daylan Perumal, Investigator Charles Ills, Investigator Patrick Mlambo, and I also copied the project manager, Mr. Sepotlale. I reference the subject as trial preparation, note 1. Colleagues, here is your Saturday homework. I'm knocking off now to watch Pirates and Sundowns, PS. It was 2:51, I've been in the office since in the morning.
Can I just
Yes.
ask a question? What's the difference between a project owner and a project manager? Because we've encountered Mr. Tlale's name before as a project manager.
Yes. The difference, Commissioner Baloyi, is Mr. Tlale is one of the 4 project managers that we have. They are involved right from the beginning of the case. They prepare our monthly reports. They are also a link between us and HR in terms of where we need resources, and they also prepare some documents, some 28s when I prepare a memo or an application, and once it's settled, they are the ones that forward same to the office of the ID, and when we receive a report back, they do a lot of work in the team. They help with the preparing for the budget of the team. When we're traveling, they are the ones who prepare memos for traveling, and when we need resources like computers and memory sticks. So they manage the whole project in that sense.
So we're in I think we've encountered Mr. Tlale and we've had a discussion about him where his name appears I think in a summons, and it says inquiries.
Yes.
My direct question to you is, does he make the decision, I want a summons, and then he prepares the application, or his is an administrative
No,
function?
it's more of an administrative function.
Okay.
Commissioner, he doesn't make that decision lies solely with the DDPP. on what type of investigations, on investigation do we go, after consulting the team.
Yes.
Whether we go at 2813 or 2818. Project managers do not make those
Thank you.
decisions. Yes.
Thank you.
I'm copying him because he must know what we're busy with, what we're doing. He keeps the file of this matter. So that is why I wanted him also to know that investigations are still outstanding in this matter. And when we're doing a case plan, he must file those. Everything that we do, the project manager must know. So I sent them this email, and the email had an attachment containing queries, and later the very same day at 3:58, I forwarded it to Ms. Innocent Sikukuni. You'll see the message to Ms. Sikukuni has an attachment document 1.docs. The email, the document, that is my document, is now on page 25 with the heading, Dear Team, 1, I have just finished reading the first dog at Brooklyn Cars in bracket, General Kumalo and others. 2, starting from Monday, I want to sit with the prosecutors, Drew and Joy, to start working on refining the charge sheet, to have it ready for the bail condition amendment application on 22 August and for disclosure. 3, as part of our preparation for the case, the response to the application for further particulars in bracket, which I'm sure we are going to be served with in due course, and preparation for the trial, I want to know the following in brackets. The questions are directed to all the team members, I was saying. 3.1, why were the accused charged with corruption? 3.2, who corrupted who? 3, do we have evidence in the docket to prove allegations of corruption against any of the accused? If so, what evidence is that? 3.4, do we agree that in terms of PRECA, the Corruption Act, the giving and or accepting of a gratification should be for a certain aim or objective? PRECA uses the word, in inverted commas, in order to act personally or by influencing another person so to act in a manner described in Roman figures 1 to 4. 5, that means a person gives another a gratification and the other one accepts or receives in order to act in an unlawful manner as out in Roman figure 1 to 4. 3.6, now following paragraphs 3.4 and 3.5 above, why did these generals in the SAPS go out of their way, rig the appointment process, risk their jobs, and flaunt the National Instruction 11 of 2017 to appoint a 29-year-old inexperienced civilian to the rank of brigadier in crime intelligence? I'm asking the question. Who is this young lady, in bracket Mokwele, for whom 6 generals in the SAPS are risking losing their jobs for? What did the generals stand to gain or expect to gain, in bracket quid pro quo, by giving her gratification, which is the position or the job? What did they stand to gain? I don't have that evidence in the docket. 3.8, what are we saying? Are we saying the generals gave Mokwele a position, stroke a job in crime intelligence in order for Mokwele to do the following? To do what? I'm asking them. What did Mokwele have to do in terms of Roman figure 1 to 4 of PRECA? 3.10, did she give or promise to give any quid pro quo to the generals? In law, she does not have to, but there must at least be an understanding between Mokwele and the generals that the job is given to her for a particular unlawful reason, in brackets, in order for her to act unlawfully as set out in Roman figure 1 to 4. She was just a young lady occupying an ordinary position at BMW at the time. I cannot see that there was anything she could offer to these generals, in brackets, except giving them cash as a thank you, or if she was having a relationship with one of the male panel members, stroke generals. I'm trying to find out why are they giving him a job which, according to the state, she was not deserving to get, And what did she do in return, or what was expected from her? 12, did the team subpoena the bank accounts of the generals and Mokwele to ascertain if she did not make any payments to them for giving her a job? If not, why not? 3.13, were the cell phone records of the generals and Mokwele obtained and analyzed for any communication relating to the application for the post, preparation for interviews, or discussions about payments? If not, why not? 3.14, were computers that were used by the generals during the period in question seized and or mirror imaged to look for communication between them and Mokwele, or, in brackets, or anyone related or associated with Mokwele, prior to or during and after the interview process? If not, why was this not done? 3.15, did the team investigate any possible family relations between Mokwele and any of the generals that formed part of the panel? Paragraph 4, colleagues, the appointment of this young lady to such a position does not make sense and is suspicious, but suspicion alone is not enough. There is a reason why she had to be appointed, and that reason is our answer. It is the quid pro quo. We must look for it, I'm saying. Paragraph 5, otherwise we remain with fraud regarding the flaunting of processes to appoint her. Yes, her shortlisting and eventual appointment was fraudulent because she was inexperienced, in brackets, which was one of the requirements for the position. Many other applicants were disqualified for lack of managerial experience. How did she make it to the top 5 and eventually top 3? 6, she also made misrepresentations in her CV, in brackets, I'm saying fraud. The investigator should follow up the validity of the project management certificate at Stellenbosch University. 7, she also claims to have been top of her class in her first year studies for MBA. She does not say where she was registered for the MBA and whether she eventually completed it. I must say later, with the investigation, it became clear that she had finished the MBA. So that information was secured after I've raised all these questions. But when she submitted the application, she only completed it after submitting the, I think a month after, in May 2024, whereas the application was in
But let me just correct you there, because in her application on page 265, that very issue you are raising, she did say that she's still busy with the MBA and she will only complete it. If you look at page 66, bottom of the page, it is expected. So at the time of submission, she did not have it, and she said so in her CV. And in fact, in her job application on page 263, the only 3 qualifications she lists as being relevant to her application. In other words, she says, I have this many other qualifications, but they are not necessary for this application because what the job requirements, what the job description requires is these 3. And then she lists all 3 of them on page 263 of file 2. She says BTech industrial engineering, and then she says the national diploma in mechatronics engineering, mechatronics. So she was saying to SAPS, for the purposes of my application, you need only look at these 2 because that's what the advert requires. I have these other things, but they are not relevant to the application. So she made that very clear. There should have been no reason to go look for things that she's not relying on for the purposes of the application. They are mentioned only in her CV because she gives a full description of what she's doing and what she's all about.
I agree, Commissioner Kumalo, and I can say that those were later clarified. The fact that she has a project management certificate, it was clarified, and affidavit was obtained from Stellenbosch University to that effect.
There wasn't even a need to do that because she was not relying on that qualification to apply for this position.
Yes.
It's a by the way that is mentioned in the CV to say, by the way, I've done these other things, but for the purposes of my application for this position, I am only relying on my BTech and my diploma. That's all.
I agree, Commissioner. It's just that when the markings were done for the interview, one of the and I think it also comes up in the email where I'm saying, but also she was given more scores by the panel for educational qualifications compared to Van Vieren and Bapela. And SACA only confirms her matric, diploma, and degree in engineering. I'll wait for your input. SEPO arrange a meeting. Indeed, for purposes of this position, those qualifications were not even relevant. But the fact that when the panel members are scoring, they consider the educational qualifications of applicants comparing one to another. We needed to satisfy ourselves that she has those, in case they were taken into consideration when the panel was marking.
Yes, but you can't say then she committed fraud. I mean, if the panel takes additional things into consideration, the applicant can be accused of fraud.
No,
What the applicant has put forward is what is required, and those have been verified.
True, I agree with what the Commissioner is saying, and I don't think there was any misrepresentation that was alleged in the charge sheet regarding the project management and the MBA, because as Commissioner is saying, indeed, in her application, she says that the MBA is going to be finalized in future. In fact, it was only finalized a month after the application was submitted.
And this thing here in paragraph 6, that she also made misrepresentations in her CV. I mean, that is not correct.
Commissioner Kumal, perhaps because we also tried to get clarity on this, perhaps explain what you meant by misrepresentations amounting to fraud in her CV.
Right. I'm calling it fraud, Commissioners, because she says in her CV, I've been a middle manager in BMW since, I think she says 2016 or 2017, from the year she started working. And we obtained affidavits, or at least at the time when I read the documents, there were affidavits from BMW, from human resource official, and from a person to whom Mukweli was reporting. Both of them say Mukweli was never a manager in BMW. She was not a supervisor in BMW, and therefore, for her to claim in the application that she was a middle manager amounted to a misrepresentation.
Advocate Seronier,
Yes. Commissioner.
what you say in paragraph 6 and what you are being asked are two different things. You say in paragraph 6, she also made misrepresentations in her CV, in brackets fraud. The investigator should follow up on the validity of the project management certificate. But you confirm that that was done. So that's not the issue. And then the CV itself is on file 2, page 265. I have been through this CV. And what you are saying is simply not in this CV, unless you can point to me
Get me the thing.
where that misrepresentation, which amounts to fraud, is set out there. File 2 on page 265. And it's a short CV, it's only 3 pages, so it's not very long.
Commissioner, I'm looking at the CV and maybe in relation to where she says middle manager, it's not coming out of the CV, but out of the application itself.
Yes.
But what she says on the CV, which is a mispresentation, is on page 267, on the last page of the CV, under accomplishment, where she says that she saved over 1 million in IT security project cost by training and equipping the internal maintenance team to carry out some of the project work.
Advocate Serune, let's agree that 267 where you are reading, it deals with successes achieved in the current role. Because she says, I successfully implemented first robotic process, I saved the company 1 million in IT security, I saved 500,000 in annual maintenance, I reduced the electronic tools management.
Yeah.
That's all she says. And in fact, the affidavit from the BMW manager says, well, I can't confirm these things because maybe other people can. That's what he says. But looking at the CV as it stands, you can't say this is misrepresentation, this is fraud. I think for now, let's just accept that unless you can show that what is stated there, those are not accomplishments and that is false. There is no fraud there.
That, Commissioner, that is what I'm saying,
Yes.
that if BMW cannot confirm that,
Yes.
that she saved them 1 million, as she's stating in here, in the account, then she's making a presentation. And if I'm a panel member and I'm reading this CV, it's very impressive that we're looking for a manager. If we can get a person who can save a company so much money, then probably this is one person that I can shortlist. But BMW says now that information.
I think what I wanted to do was to show you that in the CV, the misrepresentation that is mentioned in the memo is not in the CV. I know where the problem could be on the issue of whether she has appropriate management experience.
Yeah.
But that is a different topic, and maybe we will deal with that later on. For now, continue with the rest of your memo, because I was not probing you, but I just wanted to point out to you that the MBA issue, what she said in the CV is actually correct.
True.
And all the qualifications that she listed in her job application and her CV have actually been verified. And you've confirmed that.
I do,
Yes.
I do.
So
yes.
where there might have been a question mark is on whether she has appropriate management experience. But that's an issue for interpretation, because it's a term that is defined in another document, and even the way it is defined is a bit vague. But the CV as it stands, the qualifications are there, and there's no issue with them.
I agree. With regard to the qualifications, I agree. And like I said, those were verified, Commissioner. The issue of her being a manager, like I'm saying, if we have witnesses from BMW saying she was never a manager with us, that's the only information that we're working from. I cannot say, well, I must interpret her CV or her application otherwise. If BMW says she was not a manager and she says she was a manager, then to me it's a misrepresentation. I was going to call those two, if I was doing the trial of this case, I was going to call those two witnesses from BMW, human resource and immediate supervisor, who would have said to the court, she was never a manager with us. And therefore, how is she then shortlisted if one looks at the requirement of 3-year managerial experience in the field of the post? That is what, to me, at least at that time.
Yeah. No, and that
appeared to be fraud.
is a fair question to ask, but I will deal with it with you when we get to the national instruction.
Thanks, Commissioner.
So I have a slightly different question, but maybe before I I ask you my question, let me say in tongue-in-cheek, that if you called those two BMW witnesses, I would have asked, is this an IDEC matter after all? I say that tongue-in-cheek. My question is, your memo seems to me at least, to cover or to raise questions that I would expect a prosecutor to ask before there is an arrest, before there is charging and people are made to appear in court. You seem to be asking basic questions. Am I correct in that observation?
You are 100% correct, Commissioner Baloyi. These questions, the team ought to have asked themselves these questions. When I come in 2 months after the arrest, I was not supposed to be asking these questions, especially if a person is charged with, that's what I'm saying, why did you charge them with corruption? Because I'm looking for the evidence of corruption in the 4 volumes in the docket. I can't find any evidence of corruption. The question that I'm asking, the team ought to have asked itself before making a decision that we are now ready, we're going to arrest. They should have asked themselves, are we going to be able to prove a gratification? Are we going to be able to prove that Ms. Mokwele received a gratification? And the intention element which the authors, Steyman and them, say, in order to denotes the intention element. That is why I keep on asking, in order to do what? She does not have to do anything to say, oh yeah, no, she gave them 500 rand or this or that, but the understanding between the parties that we're giving you this, we are corrupting you basically, and she's receiving on that understanding. These are questions that the team should have asked themselves. And the commissioners will see as we go on in one of my other memos, even if that had happened, I'm raising another question later, but your charge sheet is defective in a sense that you're charging them with section 4 of PRECA, which says, for subsection 1, paragraph A, a person, a public officer who is, so it talks to a public officer who is given a gratification and who accepts or receives or promises or agrees to accept a gratification from, paragraph B, a person, from another person. Therefore, the reading of PRECA will tell you that the way they drafted their charge sheet, it was vice versa. They are saying the generals gave to a civilian, the generals being public officials. If one were to stick to the language of section 4, it ought to have been the other way around. The civilian should have been the one who was giving gratification to the generals, not the other way around. Because the generals are referred to in 4.1a. They should receive, not give. And this civilian should give, not receive. But in their charge sheet, they were having it the other way around. So these are issues that ought to have been looked at, and maybe the charge sheet also interrogated. But in relation to this is about evidence. Do you have enough evidence to go through your intended charge of corruption? My view at the time, Commissioner Baloyi, was that no. They should have been asked right from the beginning. But then you arrest. After arrest, it's only when you start investigating. Now, somebody can say, okay, what if Sirunya did not come on 8 August? I wouldn't have asked these questions. Were you going to go on with that evidence that you had at the time? Was that sufficient? Would you have convinced the court that you have a prima facie case of corruption?
Colonel Parachi thought so, that there was enough to persuade a court that she would have committed a crime in the future, therefore she's guilty of an offense, an unknown crime. So someone in your office thought that there was a good case here, including of state capture.
Yeah. No, I don't agree with that. Definitely, it shows, if you read this as an independent person who comes after the fact, it tells you immediately there was a lot of investigation still outstanding. And you couldn't have arrested go through the processes, bail application stuff, and then only do the investigations after. Especially, commissioners, that we're dealing with a high-profile case, or at least a case that involves the high-ranking officials in government. You don't just arrest people, put them into the court system, only to postpone for investigations. And these cases, we prepare them over a period of time. It's like in the lower courts where we receive decision dockets. I must prepare it in such a way that there's at least a prima facie case. When I put it on the court roll, the one thing that I must do is to postpone to seek a trial date. If the defense says, give us copies of the docket, to postpone for disclosure. But not to put a case on the court roll, which we have worked on. This case, I understand, started in December or November of 2024. And by June of 2025, they put it on the roll. For that 6 months, these issues ought to have been covered. You don't put it on the roll only to postpone it for investigation.
Is it fair to say that your memorandum, the questions that you're raising, suggests that your view at this point was that you don't even have a prima facie case yet, at this point?
Clearly, there isn't a prima facie case. When I asked them, for the first question, why are the accused charged with corruption? You know, who corrupted who? I can't see it. There's no corruption. Who corrupted who here? So there's no prima facie case, not even on the lowest standard of corruption. There isn't.
Did the ID engage you about this memorandum where you're saying we don't even seem to have a prima facie case? Did she come back to you and tell you, no, you're wrong, we do, and these are the reasons?
But now, Commissioner, I was never engaged by the ID on this memo. At least the investigating officers tried to respond to some of my questions.
Yes.
But what they did basically was just to recite what the Act says, and not to deal with the questions.
Thank you.
You were actually playing devil's advocate because this is engagement between you and your colleagues. It wasn't you forming a conclusion one way or the other. You were simply saying to them, let's cover all the tracks. Let's make sure we've investigated this, we've investigated that. And I think all your questions, to be honest, are fair questions to ask if you are given a docket for the first time and you look at it. And then you say something very important somewhere in your statement, because you say even the arrest warrant should not have been issued on these facts.
Indeed, Commissioners, on these facts, there was no case. It couldn't have been. And maybe on the issue of the warrant, Commissioner Kumalo, when I first read the docket, because the statement applying for the warrant forms part of the docket, I remember having a discussion with Advocate Lachwa and asking her how did the magistrate authorize this? And I remember she told me on the first occasion when Brian Barayashi went to court to ask for a warrant, the magistrate turned him away, saying a statement.
So the one that was issued was the second one?
It was the second one to try.
There was one where the magistrate refused to grant the warrant.
There's one where, yeah, there must be one where the magistrate refused to issue a warrant, because the magistrate was not convinced that there was a case. The magistrate who sits and does this, so the magistrate sent him back, and he went and compiled another one, went back, succeeded with the second one. But still, when I looked at the second one,
But why do you say it looks more like heads of argument than an affidavit?
It's because when I read it, it's like a person is trying to, it's like an argument. He's trying to justify why we want to have a warrant issued. But if you have
Chair said it has more conclusions than facts. That's how Chair put it.
Which I agree with, Commissioners. If you have a case, you have a case. You're not going to struggle with drafting an affidavit to apply for a warrant. And as a prosecutor, you're not going to struggle to draft a charge sheet. If you have a case, you have a case. And I always say to the juniors that come in as part of training, I say, you will see, when you struggle to draft your charge sheet, you must know that there's something wrong with your evidence. If a person stole an item at OK on the 4th of August 2026, your charge sheet reads theft on such and such a day at or near OK Central, this person stole this item, you even describe it worth so much. But if you're struggling to put it into words, what did the person steal, where, when, then it tells you have a problem, which is what I was encountering as I was writing this email. Who corrupted who, how? There was no evidence to support all that.
After your recusal, you may not necessarily have details, but I'm interested to know whether your questions, I know there was a response, but whether the substance of the issues that you were raising, to your knowledge as we sit here now, was the substance of your questions ever answered cogently?
Chair, they were not. And maybe that is why I wrote a second, or at least in the third trial preparation note. They were not. And I was saying to the evidence leaders as we were preparing this affidavit, and I said, well, I recused myself at least a month and a half after getting it, but if I had gone on and those questions were not answered, I would have withdrawn this case. I would not have prosecuted this case on the basis of the evidence available at the time, unless if all of these questions were answered. I would not have proved a case in any event, even if I went on trial, at least with the available evidence. So I asked questions and I made a follow-up, and I think I sent a third trial note where I got the response was confirmation of Ms. Mukwele's qualifications and one or two other things, but by and large, my questions remained unanswered.
Yes. I'll make a comment that I've made repeatedly during the testimony of the IDEC witnesses. We are not asking these questions so as to pronounce on whether the generals or the officers are guilty or not. But we are asking questions that may touch on whether there was a case at all, because for us at issue is whether charging the generals at all was improper. So questions of whether there was a case to start off with may be relevant to that question, which is relevant to what we are about. No, I thought I should just again, for those who may be asking themselves, but are they a court that's going to answer the question of guilt or not? So I thought I should just again repeat that comment. It's probably for the third time that I'm making that comment. Let me ask another question. When you sent your email with your several queries on the 16th of August 2025, just before you went to watch Pirates and Sundowns, you also copied the Advocate Johnson's PA, or you sent her separately. And your cover email to which you attach the queries, you say FYI, which means for your information. Here's what I want to understand. On internal IDEC processes, what would your intention have been? Would this have been for the information of the PA only, Ms. Sikukune, or did you believe that she would not hog this, but that she would forward it to her boss, Advocate Johnson? And if your response is the latter, why did you not say this is for the information of Advocate Johnson? Then that way there would be no question that this would end at Advocate Johnson's desk.
Thanks, Chair. Chair, that is how we communicate with the ID. She's receiving, I would want to believe, numerous emails on a daily basis, and therefore the practice then is we send to her PA, who then sends emails to her. But if there's something urgent, she has said that to me on a number of occasions. It was on a private matter when I was off sick, and then I sent the email to Sekhukhune. And they said, no, Peter, when it's that urgent in the morning and you're not feeling well, please send it directly to me. You can copy Ino, but also send it to me. So if it's urgent, then you even call her, say, ID, I've sent you an email, please check. But when I send it to Ms. Sekhukhune, I'm sending it to her to forward it to the ID. That was the practice, or that is the practice in the office, and I'm sure that she gave her this email. I did not receive any response from the ID on this one, but on the other emails where I did something similar, the ID would have responded to me to show that Ms. Sekhukhune forwarded to her.
All right. That was going to be my next question as to what your experience is with regard to feedback. Would you get feedback that would indicate that Advocate Johnson would have received something that was sent to the PA saying, for your information, and saying this to the PA? You've answered my question. Thank you.
Before you move on,
Yes.
The role of the prosecutor, and you can clarify for me which prosecutor, because there's a junior, you've got a senior, you've got you, the DD, but then there's also the prosecutor at the NPA, as we've understood, they get to approve something. When it comes to the warrant, applying for a warrant of arrest, what are the approvals level? Who finally says something that enables, let's say, a Colonel Pariachi to go to a magistrate and eventually get their J50?
Commissioner Baloyi, what happens is when the team that's working on a case comes to a point where they are of the view that they are ready to enroll, they make a presentation to the ID, and with the CEO, head of operations, Mr. Soko, sitting in. So it is at that level where decisions are taken to apply for a warrant. I must be honest, I don't expect, and I've never seen the ID reading to a point of reading the IO statement. I don't expect her to do that. But in these memorandums that are sent to her, prosecutors would have summarized the evidence in the docket. This is 820, it is the affidavit of Brian Parayashi, which says the following in brief. Therefore, but in the actual engagements with the ID, they must say to her, we are ready, these are the charges that we want to proceed on. Our application for a warrant is ready. Here it is, ID. Our bail statement is ready in case you're going to oppose bail or not, but we've drafted that, and those decisions are then taken. Go ahead, or no, I'm of the view that you still have to do 1, 2, 3.
So it's the internal, the IDEC internal prosecutors that look at this application and the affidavits before Mr. Pariachi takes it to court. Takes it to a magistrate who approves the J50. What I'm trying to understand, and it's been a question of concern, at least for me, but where were the lawyers? Maybe Colonel Pariachi can be excused because he's an investigator, but there must be some meaning to prosecution-led investigations, and so you say to us, Colonel Pariachi went to the magistrate the first time and he was turned back, right? Then the question is, well, does it mean the lawyers in there, the prosecutors, had never looked at his work before he went to the magistrate? So I asked the question to try and understand how it works, because it is an important question. What is the role of the prosecutors in what turned out to be a big mess in process.
Indeed, Commissioner Baloy, the prosecutors are there to do exactly that, to advise on legal issues, to read these affidavits. The affidavit would have been drafted by the investigating officer. But before he goes to the court to ask for a warrant to be issued, internally, the team looks into the affidavit. Each member of that team has a copy of the docket. They read the docket, they discuss these things. And the prosecutors are there exactly for that purpose, to advise on those issues. And the other thing is, once they agree that you are going to arrest, then the investigative officer Padayashe would have drafted a warrant, a J50 warrant. That warrant is first authorized by the internal prosecutor to.
In this case, the internal prosecutor, you were not there at the time. In this case, the internal prosecutors would have been either or both Ms. Tlachwayo and Ms. Ramsamy.
And Ms. Ramsamy.
Yes.
One of them would have then authorized that warrant. And for one to authorize the warrant, you therefore have to read first this affidavit.
Yes.
And to say, yes, we have a case, I agree with this. And the warrant also states the charges, I agree with the charges. Then the prosecutor authorizes that. Then the IO, Mr. Parayashi, takes his affidavit and the warrant, the J50. He goes to the magistrate to ask for a warrant to be issued.
Okay.
There's always a magistrate who's on standby, who's dealing with these issues. The magistrate will also do the same, go through the statement. If there's a charge sheet attached, go through the charge sheet. And if he's convinced that there's a prima facie case, and then issue a warrant.
Thank you. Thank you.
Let us take the lunch adjournment. Let's adjourn and resume at 2:10.